Welcome to the Understanding of Asset Protection Planning, and my guest today is Doug Ludmill. My name is Joseph Longo. 25 years I've been involved in this area of law, which is estate planning and asset protection. I'm also a certified Major League Baseball player agent, and we have a 50 Major League Baseball players as clients. We do all their estate planning and asset protection, as well as a lot of high net worth individuals who are not athletes. We do all their asset protection and estate planning. My guest today is Doug Ludmill, who is the principal of Ludmill & Ludmill, the premier asset protection law firm in the nation. He's got close to 20 years experience, and a lot of his concepts and strategies you won't hear anywhere else, and they work.
Thanks, Joe, for having me on. I'm really happy to be talking about this subject.
Okay, why don't we get to our mission today? Okay, so today the goals are going to be fourfold. One is to protect your money, reduce your estate taxes, identify tax-saving strategies, and protect assets from lawsuits. This is a really important one, this last one, and this is the one we're really going to hone in on today. Now what you need to consider, it's a two-prong. A lot of people confuse that estate planning and asset protection are the same thing. They're not. Estate planning is one component of this plan, and asset protection is a second component of this plan. If we can combine the two, we've got a really airtight plan for any family. In estate planning, the focus is to avoid estate taxes, avoid probate, maintain privacy, and maintain continuity of control. Now, what an estate plan cannot do. At this point, I'm going to bring in Doug and have him comment on this area.
So yeah, Joe, what an estate plan is great at doing are those four things. I mean, passing assets, making it smooth, minimizing estate taxes, making sure that the people you want in control are in control and you don't leave problems. And for the past 100 years, that's pretty much what every estate planning attorney focuses on, is just doing those things. But what it can't do is actually protect your assets while you're alive. And there is confusion, you're totally right. People kind of go, oh yeah, it does protect your assets because their estate planning attorney has said, oh, this will protect your assets. But what they mean is protect it from probate, protect it from excess taxes. They do not mean protect it from lawsuits. And the reason that an estate plan can't protect it from lawsuits is that an estate plan is revocable by its nature. You can change it before your death at any time. And therefore, a judge, if you get a judgment against you, can just say, well, I don't care what your plan at your death was, you now owe this person $2 million and go ahead and pay them. So a estate plan is not good for protecting against lawsuits. And that's where we really get to that second prong of your two prongs, which is the asset protection specific planning. So the question usually comes up, is this necessary? Because again, it's a fairly new focus area. And when I say new in legal terms, that's 30 years new. It's not new to us at all, but new in the 250-year history of our legal system. And so, a lot of people say, is this necessary? Well, the answer is it depends. Here's what you're facing in this country. I mean, we by far live in the most litigious society in the world. $300 billion a year are estimated to go through our legal system in terms of costs, fees, legal expenses, judgments, awards, settlements. I mean, it's a massive, massive industry, and lots of money changes hands. And we all know what happens when you're in a massive industry where lots of money changes hands. There's a lot of room for corruption. There's a lot of room for abuse. And that's what's happened. In certainly my opinion, I see just tons of abuse of the legal system. People suing, people just because they know that they can force a settlement out of them, because the lawsuit itself is so damaging and expensive. And we see that in this big increase in lawsuits that aren't covered by insurance. I think 30 years ago, when our parents were practicing law and growing up, it's different. I think lawyers kind of said, well, if there's insurance, I'll do it. If not, no. Today, I think that's very much not true. Of course, they like suing insurance companies, but they have no problem suing individuals if there's money to be had. It's just become a financial decision. And things like employee-related lawsuits, and certainly if you own a small business, if you have any assets at all, you're definitely a target. And targeted professions, which I think is really appropriate, in your case, Joe, because we're talking about, professional athletes. I mean, I don't know if there's a better example of a targeted profession. Guys that make a ridiculous amount of money, very high profile, everybody knows what they're doing all the time, they're followed. I mean, it's pretty hard if you do slip up to avoid a problem.
That's true. When they publish in the newspaper what you're making, people think it's fair game to pursue you in a civil suit.
Yeah, they know what your contract is, and so they know what you've got. So this kind of gets into the next one, which is who needs asset protection? I mean, who should be thinking about this? Who should be watching this presentation really keyed into what we're talking about? Certainly, it's anyone in a high-risk profession or practice. We just talked about it. Professional athletes for sure. Please, if you're listening to this, call Joe, because you are really a target, and planning done before is extremely effective. Anyone with employees, I mean, like the small business owner we just talked about, they probably have more risk as a small business owner than they do as a doctor, if they happen to be a doctor. I mean, employees are a huge risk. Anyone with equity in their assets, anyone with assets is what I'm really trying to say there. And really anyone who's not sleeping. I mean, if you worry at all, if you spend any of your time at all considering what would happen if you got sued, because of any of these factors, you should be thinking about asset protection.
Doug, what kind of claims will asset protection planning address?
Yeah, and the answer is all claims if it's done right. And that's the big distinction, because you probably hear it, Joe, that this is, I've got insurance, so I don't really need to worry about it. The big distinction between asset protection and insurance is that asset protection covers the asset, whereas insurance focuses on the liability. So, you have to buy insurance for your car driving activity. You're actually not buying insurance on your car. You're driving it on buying it on the activity of driving the car, right? Same with your home, same with your airplane, and you have to identify the risk. The insurance company has to underwrite the risk and then determine how much to charge you. Asset protection is the opposite. We focus on the asset that we're trying to protect and putting it in a place where it would be very, very difficult for anyone to get it out except you. And so we use both. I'm not telling anybody that needs insurance or has insurance to drop it and just do asset protection. I am saying don't have it as your only line of defense, because insurance can absolutely fail, coverage can fail, insurance companies can fail. The claim could just be excluded from anything you think you have covered. I've seen many cases where the person who paid the premiums all the years, when they finally make a very large claim, the insurance company denies the claim. Not because they really aren't covered, but because the insurance company has taken the position that if they deny really large claims, they come out ahead financially. And so you end up fighting your insurance company in addition to fighting the underlying claim. It's a big deal. Right. So insurance is valuable, but not as a standalone.
Okay, great. Now the asset protection tools. Let's get into the nuts and bolts of how it works, Doug.
Okay. So today we're going to talk about three big tools. The limited liability company, which probably most people listening to this have heard of, have seen, work for, have one in place, etc. The asset management limited partnership, which is similar but distinct, and then the bridge trust, which is, we're going to spend a lot of time focusing on that, because that's really of the new breed of asset protection tools called an asset protection trust. And that's really kind of the key to the whole plan. So the limited liability company is just a fantastic, great first level tool. It's great for risky assets. It's great for, holding an office building, rental property, a business that you're doing, or a business that your wife is doing, or that you do on the side. Any kind of inherently risky asset. If you have a boat, you have a $300,000 boat, it would go into an LLC. So it segregates these different assets into different risk pools. By way of example, I had a call recently from a guy who had 3 properties in California in an LLC. One of the properties had a mold issue, and the mold issue was massive. It was going to be about an $8 million claim. The properties were each worth about $1 million. The problem with having all three in one LLC is that now you have all three properties subject to that $8 million claim. If they had done three LLCs, then we would have had one property, the one with the mold at risk, and the other two would have been segregated and protected. So that's a great use for LLCs to separate valuable assets from each other. And then it has this thing called charging order protection. And what that means is that unlike a share of stock, which just represents pure ownership, so if I own a share of Apple stock and I have a judgment against me, the judge can say, Doug, hand over your share of Apple stock and we will give it to this judgment creditor. And then they can sell the stock and keep the money. But if I have an LLC interest, which also represents ownership, it's not a stock certificate, it's a membership interest. And just like a membership into a country club, there are restrictions on membership. You have to meet the qualifications. And a judgment creditor does not meet the qualifications of membership. So they can't actually seize my member interest in the LLC, hand it to the judgment creditor, and he can go sell it. The best that judgment creditor can get is called a charging order, which basically is just an IOU that if I, as the member owner, ever get a distribution from the limited liability company, then that charging order holder would be entitled to it. But it's a significant difference than just grabbing the share and being able to liquidate the underlying asset. And that's why LLCs work, and that's why we use them. The Asset Management Limited Partnership, specifically the Arizona Asset Management Limited Partnership, is the second tool. It is similar but a little different. We use that as your family holding company. That's really the thing that we want you to consolidate your assets in. It can hold your interest in those LLCs that we just talked about. Let's say if you own some rental property or a business or a boat, etc., that can be held inside of the limited partnership. And it has, particularly in Arizona, some of the best charging order protection of any of the states, which is really why we like Arizona. There's also no annual fee or annual report that's required in Arizona, so it's extremely easy to manage. We're very big on the philosophy of keep it simple. I want as few moving parts as possible to achieve the goal of protection that our clients want. And finally, because of this distinction between the general partnership share, which has the controlling share, and the limited partnership share, which has the ownership share, we can connect that bridge trust very, very efficiently to it, which is, again, since it's connecting to your holding company, which has the vast majority of your assets, you end up with real protection. And it adds a little bit of privacy. And I will say privacy is not secrecy. Asset protection plans should not be built on secrecy, meaning nobody knows where the assets are and that's how they're protected. If you're going to do that, you might as well just get a map and a desert island and bury everything and hide it. But in the real world, secrecy doesn't work. Privacy is a good thing, but you can't lie and just hide your assets. They've got to be in legal tools that have enough strength on their own to stop a judge from getting them.
Doug, would the client have to be living in Arizona to set up the asset management limited partnership?
Yeah, that's a great question, Joe. The answer is no, and that gets to this concept called choice of law. So clients have the freedom to choose jurisdictions which make sense for their needs. For example, Delaware is a very good jurisdiction if your company is going to go public because of a lot of the rules that they have. So you'll see that about 90% of all public companies are incorporated in Delaware. Apple is incorporated in Delaware, but Cupertino is in California. So you do not have to be in the jurisdiction to utilize the benefits of that jurisdiction. And so it's a great question, but Arizona, you don't have to live there. You don't have to have any connections there. You can just simply say, I like Arizona, and use its jurisdiction.
Great.
So the third tool we'll talk about today is the bridge trust. And as I said, this is really in the new breed of plans which are focused around asset protection trusts. This provides the framework for, in a real emergency, to get your assets out of the country. I mean, out of the jurisdiction completely. This is why we really rely on this as the ultimate fallback tool. It really enhances the domestic structures. So the two structures we talked about, the limited liability company and the limited partnership, this sits on top of them and gives them really teeth if we ever have an attack. It's of course not limited to any specific risk like insurance. It's going to cover all the assets that are in it, and it definitely, again, provides an increased level of privacy for your assets. Not secrecy, but privacy. What it's not, and I like to get this out up front because there's a lot of confusion. It's not a tax evasion strategy. It's not going to reduce your taxes. It's not a foreign bank account. It's not illegal. Doesn't require initial loss of ownership or control by you, the client. So it's very straightforward. And your money is never going to leave that U.S. limited partnership unless you have an event of duress, which we define as a lawsuit or something that threatens your assets, at which point we can trigger the bridge trust. The assets can cross the bridge to a safer jurisdiction.
All right, great. Regarding this bridge trust, Doug, I've seen a lot of asset protection techniques, and in a lot of it in asset protection is deterrence, right? Isn't deterrence a big part of asset protection?
Yeah, I mean, to me, it's the whole thing. I mean, it's certainly about 95% of it, because when you deter, when you have a very, very strong plan, which includes something as strong as the bridge trust, which can physically move assets away from an attacker, what you do is you put a dose of reality into that guy who's attacking you, because they have to spend all sorts of money to get a judgment against you, and if they realize that that judgment is going to be difficult or nearly impossible to collect against, they're deterred from even going forward. And that's just way better than winning a long, drawn-out battle. In fact, I put a quote up here of my father, who's been practicing almost 50 years, and he says, I can definitively say that deterring a lawsuit is far better than winning one. I agree. I mean, I'd rather avoid the fight with the guy, especially if he's a big guy, than get in a scrap with him and scrape out as a winner. It's still going to get you bloody. It's going to be lots of expense, cost, years of stress. So when you have strong asset protection in place, especially as a high-profile guy, I mean, kind of just to bring it back around to the professional athletes, if you already have a very public, level of wealth and you're followed on all over the world as a star, this is even more important. You want to be able to say,
Agreed.
hey, I take a real close look at me. Yeah, I have a $60 million contract, but guess what? You're not getting it.
Agreed. It's a good point. I agree with your father.
Yeah, me too. So, so here, why don't we just put it all together visually, so the visual people out there can kind of get a sense. So I'll lay out all the tools: the asset management limited partnership, that LLC, which here I say let's put a piece of real estate in it, the bridge trust, which is what we've been talking about, and then here we still have a revocable living trust, and that's the regular, estate planning tool that mostly is used. And how this works is the LLC is owned by that limited partnership, so we're consolidating those assets. What also goes in there is cash, stocks, bonds, real estate, all of that stuff. So at the end of the day, this limited partnership is really designed to gather up all the assets. And at this point, boom, you're here. I should probably change that lady for a baseball player swinging a bat there. You can focus on your love, on your passion. You can play baseball. You can go out and run your business. You can do your life, and you've done what you need to do. The other two tools are sitting there for one of two events. One is you're going to die, and that one we can be sure about, right? We're all going to die, at which point you really should have your estate planning in place, and everything goes smoothly, and you minimize your taxes, and yay. Or you have that crisis event, in which case we're going to follow the bridge trust. We're going to go up there. We're going to cross the bridge with the assets. We're going to get them out of harm's way. And at the end of the day, it's still passing at death through your revocable living trust. And that's really the key, and that's how it all fits together.
A question on the family limited partnership. Who are the partners?
Yeah, great question. So there's two classes of partnership. There's the general partner, which is the controlling partner, and then there's the limited partner. The general partner is typically going to be the clients directly, or in some cases, depending on the circumstance, we'll do a limited liability company that serves as the general partner. Just depends on the circumstances. And that's usually just 1 or 2%, so a very small percentage as that controller. The majority of the rest of it is going to be in the secure bridge trust or in the bridge trust. So you'll see in the little crisis area, arrow there, I have 98%. That actually represents the limited partnership interest of the bridge trust in the limited partnership.
Got it.
You could also have children there, grandchildren, other beneficiaries. The great thing about a limited partnership is it's just also a good estate planning tool.
Got it.
Nowadays there's some talk about the discounting and can we still do that. It doesn't even matter. Even if you do zero discounting, it's still a great tool to include family members in, but leave yourself into direct control of the assets, and yet get the ownership transferred down to the next level, the next generation.
Okay, great. The bridge trust, can you tell us a little bit more about that?
Yeah, that's worth some more conversation because there's really three types of asset protection trust out there. So there's the foreign asset protection trust, there's the domestic asset protection trust, and then there's the bridge trust, which we've talked about a little bit. So let's talk about each one. The foreign asset protection trust is the first. It was created in 1984 by the Cook Islands Trust Act. And the Cook Islands is a jurisdiction way down in the South Pacific, closest to New Zealand. It's an English common law jurisdiction, and it's a sovereign nation. And they decided, wow, let's create some business down here. Let's pass a specific statute that allows for someone to come down here, use our jurisdiction, just like if we're using Arizona or Nevada, and set up a trust that protects the assets of that person from creditors. And the first thing they did is say, okay, and we're going to statutorily prohibit our jurisdiction from recognizing any other jurisdiction's court orders or judicial proceedings, and that includes the United States. So that's the key to this, is that if you create a Cook Islands trust, put your assets in it, and somebody gets a judgment against you here in the United States, that judgment is worth zero in the Cook Islands. I mean, zero. It doesn't get them anything. And that's because the Cooks are statutorily prohibited from even recognizing it. So what that means is that you have to start your case all over from scratch. And there's several hurdles to doing that in the Cook Islands. You have to prove your case beyond a reasonable doubt. You can't amend the claim once you filed it, so you can't file it and then do discovery and go, oh, I found a new thing, let me amend the claim, and you just can't do that there. There's a very short statute of limitations. There's no contingent fee attorneys down there, so it's not even allowed by statute, so you're going to have to pay an attorney. So it's very, very, very difficult to actually attack and get into a Cook Islands trust in the Cook Islands. And again, now it's been over 30 years, and we have lots of case law, and we know that it is that strong. We understand and we know that it really works. So that's the good news about the foreign asset protection trust. The bad news is it costs money. It's more expensive to get that type of protection because now you're going to be engaging offshore trustees. You're going to be engaging, all of the jurisdiction and the annual fees and so forth. You also must get comfortable with this offshore trustee. Now you have somebody that's far, far away from you that you also have to get comfortable with. There's also, and this is maybe the biggest one for a lot of people, several IRS forms, 3520 and 3520A, the FinCEN 114 under the FBAR rules, FACTA disclosures. So it's very real, and none of these things are prohibitive, Joe. I mean, they don't create any extra tax, but I can tell you that for the average guy who's not really, nothing's going on. This is preventative planning. It's a little bit onerous, and a lot of times it's enough for people just to not do the planning. So that's kind of the downside to it. So the domestic trust came along much later, 1998, and Alaska said, hey, this is a great idea. Let's do this ourselves. So they created a similar statute, very much like the Cook Islands statute. And now we have 16 U.S. states that have followed Alaska and said, hey, this is good, let's do it. So we've got Nevada, we've got Delaware, we've got even Colorado, South Dakota, Tennessee. I mean, a bunch of states have said, hey, let us get into the act. This is good. The good news about that is that all those IRS forms are not required because we're dealing with a domestic trust. So you don't have the 3520, the FBAR, or the FACTA disclosures. So that's a big deal for people. Also, since we're talking about a state that they've heard about, they've probably been to, it's not very big a leap for them to say, okay, I'm comfortable with a Nevada Asset Protection Trust. So those are all the good things about the domestic trust, but there's a big problem. If you remember what I said about the Cook Islands, that the very base of their statute is that they are prohibited from recognizing a judgment or a judicial proceeding from any other jurisdiction, including the United States. For the U.S. states, we are all under one U.S. Constitution, and Article 4, Section 1 says, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And so what that means is Nevada can draft a statute that says that asset protection works, but they cannot ignore a judgment from California. And what's happened in fact is that these trusts have been around for half as long as the foreign trust, and yet we've already got many more cases in which the trusts have completely failed to protect assets. And so a domestic-only approach is really questionable at this stage. Certainly, I personally don't use it at all. I just don't find any circumstances where it's the right choice. And I would say that anybody considering it should really look carefully at all of the downsides to it, because there's just no way that Nevada, Alaska, or Delaware is ever going to be able to just say no completely to another state's judgments or a federal bankruptcy court or a federal district court or the Supreme Court. So we've got some real concerns about a domestic-only approach.
With regard to the domestic approach, does the client need to live in the particular state under which the trust is the laws of the trust is drafted?
Yeah, that's really a great question, because technically the answer is yes. So when you have those states that have domestic asset protection trust legislation, they're drafted for the citizens of those states. So theoretically, if you're even going to attempt to use one of those domestic jurisdictions, you should live in it. So that kind of leads to, what would be the one exception of case where you'd say, Doug, okay, just do a domestic asset protection trust? Well, number one is you'd absolutely have to live in the state of the jurisdiction that you're going to use for the trust. And two, you'd have to make sure that absolutely none of the exceptions to the coverage, which include, divorce, judicial, any kind of equitable settlements, child support, there's a whole list of exceptions to the planning. And three, you just have to be comfortable that, you're going to just take your risks in the domestic court. So you can create a trust not living in the state where the trust is registered. So it doesn't prohibit you from living in California or in Arizona or in Florida and saying I'm creating a Nevada trust. It's just, is it going to work in Nevada if you ever get challenged? That's when the question will come in.
Okay, great.
Yeah. So my question to myself was, what can I do to get the strength of that offshore but keep it as simple as the domestic? And that's really where the Bridge Trust was born, out of me answering that question. And so what the Bridge Trust is a trust that combines the best of those two jurisdictions, the best of the offshore world with the best of the domestic. So it's an offshore trust which is considered domestic for U.S. tax purposes. And therefore, there is no IRS reporting requirements of any kind. There's no requirement of a foreign trustee to be in control. In fact, the client can be their own trustee. It's typically less expensive to begin. It's typically less expensive to maintain. But if you're ever truly threatened and you have to cross the bridge, you can do it, and the trust becomes a fully foreign Cook Islands Asset Protection Trust at that time with all the protections of the Cook Islands. And in the meantime, it's even simpler to maintain than a domestic asset protection trust, because you can be your own trustee. And when I explain all three of these options to clients, 95% of them choose the Bridge Trust. I mean, that's what they want. They want that protection, but they also want the control and the simplicity of something that they can understand.
Doug, this is exactly why I chose you. The Bridge Trust is the trust that is most appropriate for most people. And so how do you begin? How would one go about starting this process?
Yeah, I mean, the best way for anybody listening to this to begin is with an analysis, which means you get on the phone with Joe and with myself. We literally will look at your assets, we'll review them, we'll tell you what's already protected depending on the state you live in and the type of asset that you have, and then we'll make a very clear, detailed recommendation about what you can do. If you need an LLC, a limited partnership, or even the Bridge Trust, we'll tell you exactly, make a clear recommendation to you. And then from there, you can have the information you need to make a great choice about your own planning.
Great. Well, Thank you, Doug. And like you said, call us. I'm available, and even in nights and weekends, our service is available to make an appointment for you to speak with us. So I thank you, Doug. Thank you very much for your time today.
My pleasure, Joe. Great to be on the webinar, and I look forward to working with clients together.
Thank you, Doug.